Okay, so I've got this book now. So I've got page from 144 to from page 44 to 112 to read. That's the parliamentary privilege section. And then the other section of interest is a section on actual petitioning. So this is not actually law, this book. This is just Erskine May, their own personal opinion. But this book actually, it's used as the guidance book, that it's meant to be the staple standard guide book, but it's not actually law. Although this Erskine May, obviously Sir Erskine May, but, you know, then again, so what? I mean, there's plenty of arguments been all the way through history. What caused the Bill of Rights, the 1688 Bill of Rights, to be enacted was because of disputes and arguments around and concerning the rules, particularly things like the right of appeal for Scotland, which resulted in the Appeal at Jurisdiction Act, loads of barristers and lawyers challenging Parliament over all kinds of statute laws. But now that I've been, I think, reading this, now that actually reading the statute, the main statute laws on privilege, which all the way through the statute, it's saying that actions can be prosecuted against members of Parliament between sessions, and the fact that it's based on the Charter of Liberties, and then the 1688 Bill of Rights was only an additional, it only came in 1688, which is, I mean, from 1100, you know, 11, you know, with you know, it's just, you know, like for it's about, you know, something around, you know, 400 or 500 years, you know, until the Bill of Rights, and then from the 1600s up till now, and then now we've got all this Constitutional Reform Act nonsense from Gordon Brown. So it seems to me that it's quite debatable, and further to that, I don't think that really the members of Parliament don't really, they don't really like the right to petition of the public. Once they get elected, I don't think that they are great fans of the right to petition, because it does give the members of the public powers and privilege, and all these elected members like to be the ones who make the decisions in Parliament. It's a miracle that the right to petition got enacted in 1688. So how I'm gonna do this is that I'm gonna read kind of like 2 pages at once, each 2 pages that are open. And then I'm just gonna like verbally make notes from them. So the opening part, it says, both houses of Parliament enjoy various privileges. I mean, actually, what I'm gonna actually take photographs of all of these pages of the book, because it's quite a thick book. But when you narrow it down to this section, what we're interested in, because the Parliament website does not have all of the information, it's kind of like being quite selective and filtering of. I get the impression that Parliament there's certain things they don't want people to read or look at or know. So they leave out things that they don't want you to know and read, and they just put things there. And then they also like to frame their own advice and frame their own guidance, how they'd like people to interpret it, not actually what the pure law is. And Erskine May is not the law. So I'm just gonna, because if I just like go through it and make the video all in one, it'll take quite a long time, if there's like from page 44 to 100 odd. So, but I'll do these 2 pages now as I first open the book and read them, and then you'll get an idea of how I read it and how I go about interpreting it, because I believe that is like a better clarified scrutiny of the book. So it says, this is the chapter on privileges where it first starts. So, both houses of Parliament enjoy various privileges in their collective capacity, as constituent parts of the High Court of Parliament. So Erskine May believes that Parliament is a court. Well, this is, and remember, obviously, this is before the Constitutional Reform Act, right? But I wanted to get an idea of how they're framing it, because this is written after the 1688 Bill of Rights, so 1800s, I think this is. So constituent parts of the High Court of Parliament. So Erskine May, this is important. Erskine May is not wording the High Court of Parliament to be merely placed in the House of Lords as a sole judicial capacity. Erskine May is clearly wording this, saying that the High Court of Parliament it is from both houses being constituent parts. And I think that's important, because usually, traditionally, they only seem to refer to the House of Lords having a judicial capacity or judicial powers. Here, Erskine May is saying that both houses enjoy various privileges in their collective capacity as constituent parts of the High Court of Parliament, which are essential for the support of their authority and for the proper exercise of the functions entrusted to them by the Constitution. Well, actually, it's entrusted by the people who elect them. But, you know, Constitution, we can say it's entrusted by the people who voted for them, or else they won't be in Parliament. Other privileges, again. So we've got various different privileges, and it hasn't actually yet said what is what. He's just generalising. Other privileges are enjoyed by individual members, which protect their persons and secure their independence and dignity. So that's the first paragraph. When I read this, there's more than a double space mark when it says other privileges, again, are enjoyed by individual members. I can't but help but take an innuendo and an intuition that when they put other privileges, again, are enjoyed by individual members, it's true to understand and know in your mind that the 1688 Bill of Rights, as well as the Article 9 with the illegal prosecutions by the King's Bench, there is also the right of the citizens to petition without being prosecuted. Individuals, persons. And although it doesn't read in respect to that, how he's written it, other privileges, that is an other privilege of Parliament, but not a privilege to elected members, but a privilege of the members of the public who can petition Parliament in connection with Parliament for matters that are investigated or laid to Parliament, which is the High Court of Parliament, just as any police investigator or barrister or lawyer or solicitor is handling any civil or criminal case which is to be put before any other court of order, whether it's Magistrates' Court, County Court, Crown Court, High Court, or the Supreme Court. Police have various privileges, even though they're not in a court, they're acting in connection with matters that are going to be put to a court. So when he says other privileges, again, are enjoyed by individual members, which protect their persons and secure their independence and dignity, we've also got to take into account that there are other privileges as well for other individuals who are not members, although I know it doesn't say that, but how this book is being written, he's laid it out with a double space and a large O starting other privileges. To be honest, it's rare that you see a sentence starting with a capital O, to be honest. So it's just a little thing that I noticed there in his style and manner of writing it. But anyway, some privileges rest solely upon the law and customs of Parliament. Well, actually, the law is the law, legislation is legislation. Some privileges rest solely upon the law and customs of Parliament. Well, customs are customs, but they've actually got rules and standing orders. So if he's referring to standing orders and rules, or even instruments, he's not saying acts of law either. And customs aren't necessarily written in law, but might be customs. Some privileges rest solely upon the law and customs of Parliament, while others have been defined by statute. He's making a difference between statute and the law of Parliament, but we don't know whether he's saying, when he's mentioning law of Parliament, whether he means standing orders of Parliament or actual legislation and acts of law that concern governance of Parliament in actual acts. And also notice that he hasn't actually even mentioned the Great Charters either, like the Charter of Liberties or Magna Carta, which aren't actually acts of law, but Magna Carta is where the customs are held, because the ancient customs of England, like in the Laws of Edward the Confessor and through the Charter of Liberties and Magna Carta, you see, this is where now we need to insert our knowledge and understanding, because there are those various statutes that we've got as research exhibits which are setting out that the Great Charters, you can't make a judgment against the Great Charter, and you're not supposed to repeal statutes. So we need to take that into account as well. So some privileges rest solely upon the law and customs of Parliament, right? Many of the customs are actually contained in the Great Charters, and they're not even a statute. And he doesn't actually refer to the Charter of Liberties, and the Charter of Liberties says that the 1100 Charter of Liberties, which is the very earliest main law we've got, says that the Lords and Barons can be prosecuted like everyone else. They haven't got any special treatments until we get to Magna Carta, where it doesn't actually say that it's a privilege of Parliament in Magna Carta. Magna Carta sets the peers to be judged within their peer group by their peers, right? But doesn't necessarily mean whether they're in Parliament or out of Parliament or not. The privilege is that in the title of the persons. It's not actually in the job of working for Parliament or any privilege of the building, but actually in their titles. I think that's important for the establishment of the whole thing. From the Magna Carta, we only get the building itself as the institution of the court of, well, it says here the High Court of Parliament, but it's the Palace of Westminster, right? We only get that coming in 1688. So that's from Magna Carta 12, 15, 12, 13, 14, 15, 16. So you got at least, we've got about a 400-year sort of gap before the building even is particularly significant in it, and the job, rather than just the titles. And then from 1688, it's 1700, 1890, so it's another 200 years till Erskine May starts writing about it, approximately. So, anyway, back to this. So, some privileges rest solely upon the law and customs of Parliament, while others have been defined by statute. Upon these grounds alone, all privileges, whatever, are founded. Well, it's founded that anyone can be prosecuted in the Charter of Liberties, no matter whether they're barons or not. That is what the ancient privilege is. And then, then the barons didn't really like it that they could be prosecuted, so they started to say, oh, we only want to be prosecuted by people of equal rank and title. But so it's not based on Parliament. It's not actually the ancient laws and privileges. They're in to protect their persons and secure independence and dignity. Okay, that's in the individual, but why necessarily tie it to Parliament? It wasn't necessarily tied to Parliament at all. It was all about, in fact, it was all about dignity and their rank and persons, and it didn't really have specifically, it wasn't really parliamentary privilege. It was more a privilege of rank, privilege of honours. It wasn't actually really parliamentary privilege. So to tie it all this, so that part of it, which protect their persons and secure their independence and dignity, that part is, I'd say that is what it's founded on. But to do with the both Houses of Parliament, I'm going back to the start now, both Houses of Parliament enjoy various privileges in their collective capacities, constituent parts of the High Court of Parliament. Well, it wasn't actually anything to do with that. The idea behind it is purely on their dignity and rank. And the idea in 1100 was that if they're criminals, it doesn't matter whether you've got a rank or not. Because if you break the law, you've got to stand for the crime. Until they, maybe a lot of the, the invading Normans were getting kind of like persecuted by the native people. So that's why they said, because I think a lot of the Anglo-Saxons the Anglo-Saxon barons lost their lands and dispossessed of their lands. So I don't think they were too happy about it. So maybe the barons and lords, who were mainly Normans, kind of wanted to be only judged by other Normans. Or maybe they weren't getting treated fair. Maybe the idea was that they were all meant to be treated equal, regardless of rank, under the law. But then maybe they weren't getting treated as equally from, the rest of the population if they did crimes when it came down to court. So maybe that's why they wanted to be only treated by people of equal dignity. But they still could stand for a crime. I would have thought still accused of a crime as well by anyone else, only that the persons making the final judgment would be their equals. So I don't necessarily think Erskine May is that correct or accurate, in my opinion, but this is just how I'm reading it and how I go about looking at it. This is how when I'm reading it, this is how I kind of disseminate this. I'm kind of like nitpicking at Erskine May here. So, where were we now? The Lords have ever enjoyed them simply because they have a place and voice in Parliament. Well, that's not necessarily true. It wasn't because the Lords have enjoyed these privileges because they have had a place and voice in Parliament. It's not true. The Lords have enjoyed them because they were lords, and actually they didn't enjoy them because from 1100 to 1215 they weren't enjoying it. They weren't enjoying being barons between 1100 and 1215 because they were getting prosecuted by Joe Bloggs. So they clearly weren't enjoying it. That's why they complained to King John and got Magna Carta. Say we want to be privileged to be prosecuted only by our equals. So the Lords haven't ever enjoyed them. They've only enjoyed them since 1215. And then Parliament's only really, and the privilege of the voice and place in Parliament has only been since the 1688 Bill of Rights. And I think that although the privilege, they were privileged to be only judged by people of equal rank, which obviously in Parliament you've got people of equal ranks. But a practice is obtained with the Commons that would appear to submit their privileges to the royal favour. So Erskine May, right, this is why I'm nitpicking at this, right? So this is Erskine May writing, but a practice has obtained with the Commons that would appear to submit. It would appear to Erskine May. So he's not saying like it is, or it isn't, or he's certain, or not. He just said it appears, right? So this is meant to be the staple guide for Parliament, but it only appears to Erskine May. So, and also it says to submit their privileges to the royal favour. So, in the Charter of Liberties, 1100, which is like, this is like our, starting point for this, says that shall not bind to the crown. Shall not bind to the crown, like was done before. So I think that there was some kind of, from the laws of Edward the Confessor, I think there was some sort of kind of binding to the crown, but we don't know for certain because a lot of they haven't recorded. All of the Edward Confessor laws have not been remembered. Only there's only a limited archive of them through those various laws of Edward the Confessor that are all meant to be enforced through the Charter of Liberties. So, but then they're not fully complete. Only part of them have survived, so to say. So we don't know 100% exactly how they did do it under Edward the Confessor, but so we've only got part of it. But it's suggestive that they were treated equally. Would appear to submit their privileges to the royal favour. At the commencement of every Parliament since the 6th of Henry VIII. Henry VIII. Hold on a minute. So there must be something I'm missing out here in my ignorance, because Erskine May is calling up Henry VIII on page 1 of, well, it's page 44, but it's the first page of this parliamentary privilege in this book. Since the 6th of Henry VIII, it has become the custom of the Speaker, in the name and on behalf of the Commons, to lay claim by humble petition in the ancient and undoubted rights and privileges, and especially to the freedom from arrest and molestation for their persons, servants and estates, to freedom of speech and debate, and to free access to their Majesty whenever occasion may require it, and to the most favourable construction of all their proceedings. Well, they've got that, there's a process whereby, not the Inquisition, there's a law where anyone can, if they're accused of any crime of whatever kind at all, you can have a special procedure where you demand a thorough investigation from the king, actually. And also, the 1661 Tumultuous Act, anyone can lay petitions or give petitions directly to the king, as long as it were under like 10 persons. So anyone can have access to the king if they've got petitions to give. So I don't know what is going on about there. Obviously, you're using the right to petition because that's a privilege you're using, which everyone has got since 1688 anyway. Or at least they've got a reaffirmation of that right, especially to the freedom of arrest and molestation. Well, you see, freedom from arrest, right, so in the name and on behalf of the Commons to lay claim by humble petition, by humble petition, which we've got the right to do that as well. And their ancient and undoubted rights, which in the Charter of Liberties is that anyone can be prosecuted. But then now they get the privilege of it being only their peers, except in 1967, Queen Elizabeth II decided to pull that from Magna Carta, even though apparently Magna Carta cannot be repealed, or no judgments can be made against it. Especially freedom from arrest and molestation for their persons, servants and estates. to freedom of speech in debate and right to free access to Her Majesty and wherever occasion may require it, and the most favourable constitution of the proceedings. Well, this is the thing. It says, especially the freedom from arrest or molestation of their persons, but this is while Parliament's in session. What Erskine May didn't say there, and this is in my opinion, remember, what Erskine May is not saying there is that, especially the privileges of freedom from arrest while Parliament's in session, right? Because apparently they can be prosecuted and tried outside of session of Parliament, right? So Erskine May is either glossing over those statutes or not mentioning them here, although earlier on he was, all about his statutes and ancient rights and privileges. So this must be some kind of parliamentary procedure. I don't know which it is Henry VIII, but Henry VIII is 1491 till 1547. And Henry VIII is the guy who decided to make law to make himself the head of the church and not under the Pope anymore, not under Rome, so he could have freedom of religious practice and divorce and so forth. Because they were even religiously, they were under Rome religiously at that time. So Henry VIII, there's no main great charters or bills for parliamentary privilege that I know that really affect the main principles. So I don't really think that Henry VIII has not stood out in any of the other statutes that I've looked at or the charters of any particular significance. Maybe in these standing orders and procedures within Parliament, but they're only meant to be based on the legislation and charters. So he's still not. So we've still not. He's actually still not outright said whether or not. He's not said that people can only not be arrested if they're taking part in Parliament. To which the Lord Chancellor, we'll go back to the book now. To what the Lord Chancellor replies that Her Majesty most readily confirms, oh does she, all the rights and privileges which have ever been granted, or conferred upon the Commons by Her Majesty or any of her royal predecessors. So this is like some kind of it's a bit like when they have to take the oath. So George Galloway took the oath a few weeks ago. I was watching it, and he's like, I do solemnly swear that I will bear true allegiance to, King Charles III and his successors according to law. So help me God, right? So they read this out when they start the Parliament. The Speaker reads out the ancient and undoubted rights. They can't have that's joke, right? So this is me, right? This is me scrutinising Erskine May. This is how you've got to look at it if you're not a retard, right? If you're not gullible. So the Speaker, and by the way, I know that this Erskine May book is 1800, but I wanted to read this version of it because all the modern ones have got various bits cut out that they don't want people to read or know. It's getting worse now. In the name and on behalf of the Commons to lay claim by humble petition to their ancient and undoubted rights and privileges. But the ancient and undoubted rights and privileges are mainly and primarily in Magna Carta, right? The Magna Carta. and from the Charter of Liberties and Edward the Confessor laws are where the customs are, right? And Lisbeth, Queen Elizabeth II, has repealed half the bloody thing in 1967. There's only 4 clauses left. Luckily, the first one and the Liberties of London, which we're arguing about now with the ULEZ fines, because it's the Liberty of London, you know, supposedly no tolls by river or land through London. Luckily, yeah, you know, they've got the congestion charge and ULEZ now, which is like, everyone's scratching their heads. Luckily, the first part of Magna Carta is in effect still with the Charter of Liberties. So Queen Elizabeth, in her, you know, great wisdom, even though any judgments made against the great charters shall be holden to none and are void, from what we've learned and read so far by these statutes, Parliament opens by their ancient and undoubted rights, which have literally half have been repealed. I mean, Parliament have just, I think it was yesterday or the day before, they've just had a MP. They were all given a standing ovation to an MP who's just had some really rare disease and literally had a lot of amputations, and there was only a 5% chance of him surviving. He's just survived on a 5% survival chance, and there's hardly anything left of him. He's literally like Darth Vader or something. He's literally been amputated till there's nothing left of him. That's literally what they've done to the Magna Carta. There's like 4 clauses left. Can you believe this? In the name and on behalf of the Commons to lay claim by humble petition, this is when they open Parliament, the Speaker's petition, right, to their ancient and undoubted rights, or what is left of them. Can you believe that? To which the Lord Chancellor replies that Her Majesty most readily confirms all the rights and privileges which have ever been granted to or conferred upon the Commons, and that's not even the Lords, by Her Majesty or any of her royal predecessors. Well, that Lord Chancellor reply right there, to me, in my mind now, that seems concurrent with some of those statutes which I've added to the complaint earlier on and given citation to. Some of those statutes say that anyone who seeks to repeal statutes shall be adjudged a traitor, or if judgments against the great charters shall be holden to none or shall be void. So there's one of the statutes that I've cited that says that the king or queen may repeal or restore certain statutes that were made since a certain part of their reign, but not all of them, only within a certain time period. It says that they can repeal or restore certain statutes that were made within their a certain period of their reign, but not before. So that clearly stops them from repealing any that were made before, which is all of the older ones, the old and ancient ones, like the Magna Carta and Charter of Liberties and so forth and so forth. So where I am with it now is that Philpot, Prince Philip and Lisbeth, Queen Elizabeth, have been on a bit of a naughty spree, and now Charles has clearly left with it to clean up with, because and then there's all this, Magna Carta that you can't have your carts taken off you without your consent, like use of carts and vehicles and horses and all that with the speeding fines. I think this is my honest, this is like a proper opinion. My true opinion is that Philpot and Lisbeth went on a bit of a rampage through the 1950s, 60s, 70s, and 80s. Maybe some kind of Bonnie Prince Charles cocaine party, and got a little bit carried away with their partying, and probably thought they were like, supreme beings or gods, regardless of how quaint England is with its cottages and tea parties and, stamp collecting and frilly paperwork and books and, all the nice things in life, like Mr. Kipling's cakes. And really, there's some insidious and questionable legal actions being put through the Parliament, which it appears that not many people have been challenging them. And I think this is to do with, the whole thing with the food and the fact that, his health's been affected since World War II, sperm count's down 50%, people are in brain fog mode, drive-thrus, fast food, getting obese, cancer, overweight, and lack of access to knowledge, lack of access to information until now, when people are actually being able to get the information on the internet, online, people uploading things, people double-checking things for different versions and now scrutinising it. And what we find is that there are a lot of questionable things that have been going on, particularly with the law and legislation. So how can you open Parliament? How can the Speaker open Parliament with the ancient and undoubted rights when there aren't any left anymore, hardly? Although there's only like they're holding on to them by the skin of their teeth by the first clause of Magna Carta. Although this was written in 1800, but I think by the 1850s there's also taken the jury out of the magistrates' court. Isn't that ironic that, it started off with the Charter of Liberties that, oh no, lords and barons will be treated as everyone else, we can be accountable for their crimes. And then, no, we don't like that anymore, so they can only be treated by their equals. And then, after, we don't want commoners judging us anymore, commoners won't even judge themselves, we're stripped out of the magistrates' court. You can't even have judgment from your peers. We can't even have judgment for our peers, let alone the peers don't want judgment from us. We can't even have judgment from our own peers, is joke. But 1967, that really takes a biscuit. So this is just the kind of like evaluation for the opening chapter. So this is like 37 minutes now. I'm actually going to stop recording this video now. I'm going to upload this and I'm going to submit it. And then I'm going to, because it's going to, if I do it like this for the whole section of this book that I want to scrutinise, then it's going to be hours and hours and hours. So I think this is just like an example of how you need to scrutinise it. This is the kind of logic that is required to scrutinise Erskine May, really, and unpick Erskine May. You need to question everything and check everything, and you need to be knowledgeable and read in all of the different statutes and the origins of it. And you need to be critical. You need to be like, as you're reading it, you need to be... Every single thing cannot be taken for granted. It needs to be kind of like scrutinised the whole way through. That's how you need to approach it, in my opinion. So it's probably going to take me a couple of days because I want to do that petition section as well. So this is where I am now. So